On my far right is Sir Stephen Laws. Stephen is former first Parliamentary Counsel, so he's the sort of person who would have overseen drafting a bill like this. So very well placed to talk about all those technicalities and how government thinks about drafting this sort of legislation and what he would do. We're then going to move over to Ruth Fox. Dr. Ruth Fox is the director of the Hansard Society, deeply steeped in the ways of Parliament. Going to get Ruth to talk very briefly, answer a couple of questions about how Parliament can actually go about scrutinising this sort of rather extraordinary bill. Then my colleague Akash is going to try and answer the question about, can the devolves derail this completely? Is this going to be a constitutional nightmare? He'll have a couple of minutes to do that. And then I'm actually delighted to have Baroness Hayter, Dianne Hayter, who's the Shadow Minister for Exiting the European Union and Deputy Leader of the House of Lords for Labour. And obviously one of the big things that we have to do is say, will this be opposed? Actually, will Labour oppose this? What's the passage going to be? And actually, how are the House of Lords potentially a source of much greater problems to the government in many ways than the Commons? How will the House of Lords regard the bill? I know we've got a really distinguished audience and some people next door, so we're going to leave you loads of time for comments and questions and things like that. So without further ado, I'm going to kick off. So the format is just going to be, I'm going to ask some questions. So think of your own for when we come to you. So Stephen, I said you're the sort of person who would have drafted this bill. We thought we might have actually seen what sort of job, so you could have given it some marks, is it 4 out of 10, 8 out of 10 on quality and all those sorts of things you clearly do when you look at government legislation. But unfortunately, despite haven't quite seen it yet, I think the timing is still what we might describe politely as uncertain. But if you were faced with this challenge of drafting legislation to take the UK out of the EU, how would you have gone about it?
Well, you may be quite pleased that it hasn't actually been published, if that was the task I was going to be presented with. In some ways, it's quite a personal question how you draft a bill, because different drafters approach bills in different ways. There are two basic approaches. There are those people who like to sort out all the detail first, and then when they've got through all that, they try to impose a structure or general proposition on the top of it. And there are those, and I count myself as one of those, who are sometimes regarded by the other lot as dilettante drafters, who take a broad view of the detail and try to create a hypothesis of a proposition that will catch most of it. And then they apply the detail to that, mould that proposition and try and deal with it. And the first thing you've got to do with this bill is to provide for continuity. That's the first task. And having told you that I am naturally inclined to do it the way I am naturally inclined to do it, I don't see any other way in which you can preserve continuity. You have to try and articulate a general proposition and then work the detail into that. Drafters always work from instructions, and the reason they always work from instructions is because it's necessary to have a specification that you can test your product against. You need to be able to know what you're trying to do. And then you take the instructions, you break the task down. And in this case, the task is to provide for continuity, to provide the power to make continuity work, to provide the power to give effect to any detail, and then at the end to work out all the things that don't work once you've done all that and to deal with those. I think there are two things, perhaps, maybe three things that I need to say about how I would approach this. The first is that legislation is always about change. It's always about moving from A to B. And this is a system change. A lot of legislation proceeds on the basis that there is a change in the real world that you want to achieve. There is an obstacle, a legal obstacle to achieving that, or a lack of incentive for behaviour that will enable you to produce that. And you change the law in order to bring about the end result. Now, it's not unusual for drafters to be told to change the system without being told what the end result is supposed to be. But that's normally because there is an underlying assumption about what the end result will be and that the legal change will produce it. In this case, this is not that. This is changing a system in order to produce whatever result changing the system produces. And I'm not criticising. We all know why we're doing it that way. But what it means is that the options in drafting, if you're only interested in the route and not the destination, the options are much more complex. There are many more choices. If you start from the east coast of the United States and you're trying to get to Los Angeles, it's easier to choose the route than if your target is the Pacific Ocean, because you've got so many more options. So those are the first two things I would want to keep in mind. And then the second thing that I think is really important and is in the white paper, but is not obvious, I think, in the white paper, is that the situation we intend to create has two elements to it. The two elements are, we are going to stop EU law being a source of UK law, and we're going to stop being members of the European Union. Now, those two things are connected, but they are not, they are still different. When I first heard about all this, I used to joke to people that the continuity provision would be quite easy to draft. You just draft a provision that said EU law is to continue as part of UK law, as if the European Union were an international organisation of which the UK is the only member. And that's the problem, because some things disappear because EU law is not part of UK law. But even if it were, they depend on our membership. So you've got to decide what things you want to keep, though you're not a member, and what things you want to keep as if you were a member. And I think maybe I ought to stop there. And,
So I'm quite interested in sort of when you're doing this, so we've got the sort of Lawsian bill. It sounds like, you know, if you'd been tasked with doing this, it's probably slightly more than 4 clauses, but not a huge long bill. But then, would you have envisaged huge amounts of powers in delegated legislation? So obviously one of the battlegrounds is how much is going to be done through secondary powers and how much is going to be done on the face of this bill.
Yeah, I think I would have envisaged pretty wide powers, and the most difficult powers to make subordinate legislation to draft are those when you're not quite sure what they're going to be used for. And by definition, these are powers that you don't know what they're going to be used for, because you know what you know, and you want to take the powers to deal with the things you don't know yet, what the deal is going to be, and what are the things you've missed with your general proposition. The white paper tends to suggest that there's going to be one proposition for continuity, and everything that needs to be done to make EU law work in UK law will be done by subordinate legislation. I was the drafter in charge of the European Union Bill 2005, which was the Constitution Bill, which proceeded on this assumption that what emerged from that treaty, unlike the later Lisbon Treaty, what emerged from that treaty was going to be a completely new system, distinguished from the old system. So we needed to provide continuity from one to the other. And we made lots of assumptions about what continuity involved, and we had general provisions saying all references to the old treaties are to be treated as references to the corresponding versions of new treaties. I imagine the continuity provision here might make a lot of assumptions about how you convert things that wouldn't work once we're not a member. And then the power to put things right is a power to change the default position, not to change a blanket default position that is everything is carried over as if we were still a member, and then taking away or adding to that.
So just one final question, which is, the government's also announced these other Brexit bills. So what determines what can go in the Repeal Bill with these very, very wide-ranging powers potentially, and what needs its own primary legislation? Just why is there an agriculture bill? Why is there a fisheries? Why can't we just carry over, we'll continue to make payments as though we were members of the CAP and stuff like that?
Well, I mean, in theory, you could put it all in one bill. I think what the government is doing is separating the technical continuity from those things that require new policy. Now, I think the line between what's new policy and continuity is going to find itself rather blurred in the event, because, I mean, to take the obvious example that everybody refers to, where there's a obligation to take account of regulation by an EU institution. You have to choose a new institution if the EU institution won't cooperate in future, and that's that's regarded as part of the continuity issue, but it has an element of policy in it. But the other 7 bills are, I think, dealing with those areas where it's thought that there will be new policy needed as from the moment of exit. And incidentally, the white paper does say that EU law will apply to all bills, continue to apply to all legislation passed before exit day, and I don't think that can be right, because these bills will be bills that are not subject to EU law, and so they will have to be excluded from the application of EU law in the future as well.
Okay, it's all getting very sort of mind-bending complicated. So, Ruth, Parliament's got to make sense of this, and it's got to do a job scrutinising whatever it is that Stephen's erstwhile colleagues come up with in the government's name. So actually, how should Parliament go about that task of ensuring proper scrutiny?
Well, I think there are 2 challenges. One is, how does it scrutinise the powers in the bill that Stephen has talked about, when it doesn't, Parliament won't necessarily know how the government intends to use the powers it's asking for. So that's the first challenge. And then the second challenge is, how does it scrutinise the delegated legislation, the secondary instruments that flow from these powers after that bill receives royal assent. So there's two interlinked problems. And I think the scrutiny problem is the challenge is in the House of Commons rather than the House of Lords. The House of Lords procedures, their focus on the technicalities, their focus on things like the delegation of powers is much, much greater than we see in the Commons. And I think this bill poses a fundamental point now for the Commons. Will it finally take the scrutiny of delegated powers and delegated legislation seriously? Will it actually live up to its democratic responsibilities in scrutinising that form of legislation or not? It's a really big challenge. In terms of dealing with the powers bit first, I think there's a couple of things that they can clearly focus on. The first is, and I'm not saying this just because Dianne as a peer is on the panel, but the House of Lords, having said the House of Lords is better at this than the Commons, it would be extremely helpful if the Delegated Powers and Regulatory Reform Committee of the House of Lords, which scrutinises the powers in every bill when they arrive in the Lords, if it were to do something it has not done before, which is look at the powers on publication when the bill arrives in the Commons. Now, that might seem like a minor change, but in terms of the constitutional proprieties between the houses, that's actually quite a big step for a Lords Committee to do. And it might be helpful if the Commons somehow were to come up with a mechanism to invite that Lords Committee to do so. But part of the problem in the Commons will be that lots of MPs, frankly, don't understand delegated powers, wouldn't know where to find the delegated powers memorandum. In terms of, you look at the House at the moment, we've got 80 odd new MPs for whom this is likely to be their first big piece of legislation, first any legislation they've dealt with. How are they going to understand what on earth is going on? I've studied delegated legislation for my sins for quite a number of years, and I still have to sit with a cold towel around my head looking at some of this stuff. So you've got 18 new MPs who, frankly, are going to be all at sea with a lot of this. Add into the fact we don't have select committees set up. They're unlikely to be set up in such a way that they can do anything substantive at all until the September sitting. And you've therefore got a scrutiny gap in terms of the bill, assuming that the bill appears before summer recess. So that's the first thing. The Delegated Powers Committee really has to report first. I had to report early.
So is there anything that needs to happen for that to happen? Is there some...
Well, the Lords Committee has indicated that it's thinking about reporting straight away. We've strongly urged it to do so. I think it probably will, but there is still, I think, some understandable reticence on the part of the Lords that they might feel that they need an invitation from the Commons to do so, because its remit is to report to the Lords, not the Commons. So it would be helpful if something could be...
And who could issue that invitation from the Commons? Not an expert on parliamentary processes, as a former civil servant, confirming every ministerial prejudice here.
A committee could issue it, but that would mean delaying it.
Right.
Individual MPs could state on the record in the House that they'd like. It would be helpful to the House if that were to happen, and so on. But the Lords could take the step of doing it off their own bat, and that's certainly what we're encouraging.
Okay, interesting.
Second issue is safeguards on the face of the bill with regard to these powers. So, obvious thing could be to put sunset clauses on some of these powers so that they're time limited, can't be used for purposes beyond the specific purposes of Brexit. We know that in the past, with other legislation, powers that were set out in bills agreed to by Parliament have then subsequently been used by ministers for purposes for which they were not originally intended. So there'll be concern there, and with the best will in the world, ministerial assertions at the dispatch box do not have the certainty of something, a restraint set out on the face of the bill. So there's that option. And then there are other constraints that they could put on it in terms of certain types of activity for which the power cannot be used, cannot impose a tax, cannot raise a tax, cannot impose a criminal offence, whatever it may be, might not be used for constitutional provisions. But of course, given the nature of this unique exercise, some of those constraints might be quite difficult to apply. So considerable thought needs to be given to that. And then just the third and final thing, in terms of the scrutiny mechanisms, once the delegated legislation that flows from these powers appears, the House of Commons system is utterly inadequate. Absolutely inadequate. And it needs a new system. We will be recommending shortly a new SIFT and scrutiny committee system modelled on the House of Lords EU scrutiny system. Ideally, we'd have a bicameral joint system. I don't think there's any political will for that. I think it would be difficult to set up in the time period, and it frankly would let the MPs off the hook in terms of their democratic accountability. So we will be recommending a SIFT and scrutiny system to tackle that problem once the statutory instruments start to flow.
So what difference is the fact that, you know, we're not facing the government getting... There's always going to be a big task for government to get through with the hoped-for landslide majority. Obviously, the parliamentary arithmetic's not quite like that. So how much harder has this task become with a minority government or a government with, you know, a confidence supply agreement in place with the Democratic Unionist Party?
Well, as with any vote, it's only going to take, 7-8 MPs on the Conservative side to decide that they're going to rebel, and the government's got a problem. So in terms of some of these broader powers, the government's going to have a harder time getting them through than it would if it had had a landslide. One would hope that the MPs, you know, the DUP, for example, if they're interested in, you know, serving the interests of the Union, serving the interests of Parliament, they could do us all a very big favour by saying that if the government wants to bring forward these quite broad powers and needs flexibility, then there is a concession to be had in Parliament's interests, and that concession is around procedural safeguards and a commitment to a new system. But, you know, the government won't have a majority on the committees, so it's just going to be more difficult, and therefore there's more opportunity to get these procedural reforms in place.
Okay, it's a very interesting thought to come back to. So, Akash, the devolved, I think the Welsh Brexit minister and the Scottish Brexit minister wrote just after the election to say they weren't very happy with the way in which the consultation arrangements had been working to date, asked for a reboot, and particularly asked for a chance to see the Great Repeal Bill, which they didn't seem to have seen till then. So what's the capacity of the devolves to derail the whole process?
So I think, there's two sides to the sort of interaction between UK and devolved institutions here. There's a legislative process, legislative consent and so on, and then there's the intergovernmental consultation. And I think it's important to think about those two separately, as well as how they ultimately relate to one another. So in terms of the legislation itself, we have, of course, this thing now suddenly famous, the Sewell Convention, which has operated fairly uncontentiously all the way back since 1999, and is a commitment by the UK, by the UK government in 1999, now recognised in legislation, that Westminster will not legislate with regard to devolved matters without consent of the relevant devolved institution. And on the Repeal Bill, we of course have yet to see it, but having been a bit of uncertainty about this issue, there does now seem to be a commitment by the British government that they expect to have to seek consent of the devolved legislatures for the legislation, because it will make changes to the competences of the devolved bodies one way or the other. So it will, of course, we assume, have to remove references in the devolved legislation to, for example, acts of the Scottish Parliament must comply with EU law. Scottish ministers have the power and responsibility to apply and implement EU legislation in Scotland and equivalent in Wales and Northern Ireland. So these aspects of the devolution settlements are going to have to change, and on that side of it, it's hard to see why there would be much opposition from the devolved level, because if you were to not give consent to those provisions, but Brexit were presumably to go ahead nonetheless, you would end up with a slightly odd situation where the Scottish Parliament was still bound by EU law, even though it wasn't within the EU. So there's aspects of it that are seen as sort of technical, but where the disputes are likely to come in are much more around question of repatriation of powers from Brussels and the proposed creation of new UK frameworks to replace things like the Common Agricultural Policy, environmental regulations, fisheries management, and so on. And that then gets you into this question that you put to Stephen, which we clearly don't quite know the answer to, but what is likely to be in the repeal bill as opposed to the suite of surrounding bills, and also to what extent do you really have to think about all of that as a package, because when it comes to it, are the devolved governments going to be asked effectively to advise the devolved legislatures to give consent to a bill without there being clarity about, what are these new frameworks going to look like in terms of, are they going to be imposed by Westminster legislation, irrespective of the views of the devolved bodies, or are these going to be genuinely, a matter of negotiation and consensus between the devolved bodies? And this therefore gets me onto the point about intergovernmental relations surrounding all this, because certainly what we've seen, as you referred to in the letter between Mike Russell and Mark Drakeford, the lead Brexit ministers from Scotland and Wales, is that ever since last June, I think there's been a growing recognition that, or since July really, after Theresa May came in, a recognition that the British government has overpromised and underdelivered in terms of how it's going to work with the devolved governments. I mean, there was this commitment up front to seeking UK-wide agreement on the objectives and approach to Brexit. That was written into the terms of reference for the Joint Ministerial Committee, but that really hasn't been reflected in how this has worked. So no, the devolved governments have not seen a draft of the Repeal Bill. They didn't see a draft of the White Paper earlier before the election. They didn't see a draft of the Article 50 letter. And yes, all of these things ultimately relate to the reserved competence of membership of the EU, but it has produced, I think, quite a poor basis on which now going forward the UK and devolved governments, for them to now create frameworks to work together on all of this. So I think it's a challenging moment, and I think it will need a change of approach from down here, from the Westminster government.
Thank you, Akash. Now I'm going to come on to Baroness Hayter. Those of you who do forensic analysis of IFG invitations will realise that Baroness Hayter wasn't actually on our panel first time round. And that's because she came back to us when we issued one saying Labour would oppose the Great Repeal Bill, and she took us up on that. So we thought, why not ask her to be on our panel and tell us? So how's Labour going to react to the Great Repeal Bill, Dianne?
Well, we've certainly not said we're going to oppose it, and I was very surprised to read that. I want to say two things. Really, this is only a quarter of what will happen. This isn't in proportional size in the House of Lords and indeed in Parliament. You've got the Great Repeal Bill, you've got the stack of however many primary legislation, you'll then have the withdrawal deal that we've been promised to vote on, and then at some point we'll have some treaties, and they will presumably become under Crag. So although it's four, in a sense, quite different jobs, they will relate, and in a sense it's some of what's been said. We'll be asked to do the Great Repeal Bill before we know what's come out from those other things. As far as the repeal bill goes within the Lords, we will do the job that we do, that I think Ruth has rather well summarised. there are, of course, particular difficulties with the repeal bill. One is that, I mean, it's very detailed, so we'll love it. You know, it's our sort of thing. But of course, some of it will, the draft SIs will be very important. And we've been asking the government they should be out early so that everyone who's used to working with the regs at the moment can look and see, have we caught that right? And I think it'll be really important that we have the dialogue with the people actually using them. But there are other issues, like a lot of the regs, if you actually start looking at them, like anoraks like me do, they're actually based on some underlying, like competition policy or the Charter of Fundamental Rights within the European Union. And they are taken for granted in some of the regs. And it's very hard to see how those regs could just be lifted and shifted over. And it's possible that on occasions we may have to say that needs primary legislation, because otherwise we might lose some competition policy or anti-discrimination. So it's possible we may want to sort of try and shift things over. But the other major issues of some of the regulations, of course, is that the supervision or indeed the enforcement has taken place by an EU institution, either by the Commission itself as a supervisionary one, ECJ, or indeed some of the agencies have done the enforcement. And there are some big questions then about whether we can just put those into our regs, whether there will be the bodies here, or whether again we will need the reciprocity across to exchange information. I'm a consumer, I do consumer policy, and we work a lot with the equivalent of trading standards in other countries, and therefore there's lots of portals for exchanging intelligence. That will be the same in a number of other areas. There are big issues that lawyers here will know much more about, of the mutual recognition of, in whether it's maintenance regulations, family law and all of that. And it's hard to see how that could be done because of the reciprocity. So I think we will probably play the role we've always played, which is to go for these rather nasty little questions, but are really serious about how a bill will work, and ask those questions of the Minister.
So it's quite interesting. The reason why we thought Labour might oppose this was that in the manifesto there was a clear commitment to drop the bill and replace it with, I think it was the Employment Rights and Environmental Protection Preservation of Rights Bill or something. So we got the impression that Labour didn't really like the bill very much, or the idea. So that was just...
It's a much better title. I mean, Great Repeal Bill is rather silly, isn't it? Because Clause 1, presumably, will be repeal the 72 Act, and then all the other clauses are not repeals, they're lift and shift, and they're putting into domestic law what is already domestic law, albeit via the back door. So the name is pretty stupid. And it is mostly about protecting you use the word continuity, I think, of continuing those rights.
So it's just the name that was
and to make sure they're safeguarded. I mean, clearly we will have a job to make sure that the government does what it's promised, which is no watering down. It has said it is simply going to take the regs and put them into UK law. So clearly we must check that they're actually going to keep to their word.
This is all very high-minded. Parliament trying to do its job well. Ruth's given them some opportunities to show they're up to the game. House of Lords doing detailed technical scrutiny. But some of us are old enough to remember the passage of the Maastricht Bill through. Seem to remember that John Smith then, despite, I'm not sure Labour had huge difficulties with the Maastricht Bill, but using it as a way of basically making the government's life a complete misery by opposing lots and lots of very clever amendments and things like that, and using it as a vehicle for challenging the government and having a government almost always teetering on the brink of falling and just wearing everybody down or whatever. I mean, is the repeal bill going to be a vehicle for that sort of parliamentary action, or is Labour going to say, no, we accept the result of the referendum, we're going to do a sensible, professional bill, and our real interest is just making sure that when we leave, we lose no rights?
Well, in a sense, I think it's overselling the repeal bill. As I was saying, the other four bits are actually, I think, much, much more significant, and that's where we really need to hold the government's feet to the fire, because the repeal bill is putting into law what is actually already law. and although I'm absolutely determined we will not lose any workers' rights, they're not much good if we ain't got any jobs, because we've sold the jobs by, you know, coming out of the customs union, by doing all sorts of other things. It'd be great if we got, you know, we have the repeal bill, we keep the workers' rights, except there's no jobs. So the bigger issue, it seems to me, is trying to get the government to have a much more sensible both withdrawal, but even more the future arrangements that we have with the European Union. And, you know, what techniques we have for that, and whether we try and keep them up all night on certain things in order to get them to think sensibly about the other. But for myself, I wouldn't oversell how important the repeal bill is to our final way of how we're going to continue to trade and all the other things we do with our closest neighbours.
So Ruth, do you have any views on whether that's likely to be?
Well, I mean, I think that the nature of it, a sort of quite framework, it'll obviously be very technical in terms of this sort of amendment and continuity provisions that are required. So I think it will be harder for, particularly for MPs, to kind of hang their opposition on compared to the policy-driven arguments that it'll be easier to make in terms of things like the customs bill or agriculture and fisheries. One of the questions that I think emerges is Parliament has 11 strengthened scrutiny procedures, would you believe, that it could deploy to scrutinise the kinds of powers that are going to emerge in this particular bill. And I think one of the challenges that they're going to have, and for reasons that this is not particularly sexy stuff, not the stuff of great campaigns, and probably more difficult, therefore, to generate a political head of steam around it. But the difficulty is going to be the kinds of powers that Stephen has talked about, where Parliament is granting powers to ministers to delegate for the use of secondary legislation when it doesn't quite know how those powers are going to be used. These 11 procedures are specifically designed for that purpose, largely by the House of Lords on past pieces of legislation to in a sense control that, to put a constraint on it. The difficulty I think for this bill is going to be that those procedures are lengthier than the norm, they take a lot more time, and the question I think will be, can they really be utilised in the context of the repeal bill process and Brexit, when we potentially have got such tight timeframes and constraints at the end of this process. So I think, you know, a lot of the arguments in the Lords usually are very technical around these procedures. The question is going to be, can they really be used and deployed in these particular circumstances?
Various people have been tweeting, well, Parliament doesn't have to go away for all of August, it could sit much longer. We heard rumours before the election of Friday sittings and, you know, no private members' bills, and the Queen's speech looks like a bunch of private members' bills to me, but anyway, apart from the Great Repeal Bill. So, I mean, you could do things, if time was the issue, you can create more time in the parliamentary calendar. Do you think that's a prospect to do that? Parliament be up for that, for doing its job properly? Okay, we can leave it there.
No, I mean, I think it would not, depending upon the timing of when the bill receives royal assent, I don't think it's beyond the possibility that the summer recess next summer might be shorter because they are trying to push through a number of statutory instruments. I mean, they're not going to come through in a steady stream, I don't think. They're going to be peaks and troughs as there are now. The question is, when do those peaks and troughs arrive? And when do the first lot that they can do with some degree of certainty come through? And it might be that they decide they need more time next year, but I don't think there's any issues immediately in terms of any proposals for
So Stephen, this bill is only brought into force when we exit. So somebody suggested to me that it might be possible to have an amendment to Clause 1 on repealing the Act to say this is only repealed if we have a deal or something like that, that you could actually introduce something that said that. Is that going to be technically possible, or will the sort of title prevent those sorts of amendments being selected?
Well, it's the scope of the bill that limits amendments, and scope is defined in the Commons in different ways from the way it is in the Lords, and so far as the Lords is concerned, the rules of order are determined by the House, so that doesn't really get you very much further. I mean, I think on the political side, the area where the government is most likely to come under pressure on the Great Repeal Bill is the provision that takes the power to implement the deal. Now, there's got to be a power to implement the deal because we can be almost certain the deal is not going to be known in time for a bill to be passed after it's arrived at. So that's where it seems to me the pressure's going to come on, and that's where any amendments that limit the power to implement a deal will come. So far as opposing the bill altogether is concerned, I don't want to, for those that heard me talk about Miller decision before it was reached, I don't want to sound still bitter about this, but the context is that as a result of the Supreme Court decision in Miller, the default position now is that if no bill gets passed, we have a piece of legislation that authorises us lawfully under UK law just to drop out. So opposing, that's where you get to if you oppose the Great Repeal Bill. You get to the position where we automatically drop out after 2 years. So there's quite a strong incentive to pass it, but that incentive applies to both sides of the argument.
Okay, brilliant. Let's go to some questions. So we've got some roving mics, and I'm going to come first here to Alex too. So Tom Brake, who is the Lib Dem spokesman on exiting the EU, I think.
Absolutely, yes. Even we had to have one, unfortunately. Just a couple of questions. First of all, I suppose a question for Stephen, and that is, obviously politicians have a view about what the balance between primary and secondary legislation should be, and we want it all to be primary, or at least the opposition parties do. Do you have a view in terms of someone who has previously drafted bills? And secondly, for Ruth, I just wanted to hear a bit more about the sift and scrutiny proposal that you have for secondary legislation.
Okay, should we take those straight away and then we'll move down to Vernon? Yeah, Stephen.
Well, as between primary and secondary, I don't think there are any absolute principles. I take a sort of roughly pragmatic view of this. Parliament should agree to allow to go through by secondary legislation those things that it thinks it can accept a lower degree of scrutiny for, and that's a political decision. What's the purpose of parliamentary scrutiny of legislation? The purpose of parliamentary scrutiny of legislation is to run legislation through a political filter and to identify those things, and as part of that, because bad legislation has some political salience, is to incentivise good law, and Parliament should do whatever it thinks will achieve those objectives. I thought the first suggestions Ruth made about better scrutiny were more practical and probably better. That is, that there should be a combination of things. I think parliamentary scrutiny works through identifying the things that are important to Parliament, a sort of triage system, which is what you were suggesting, and also by a degree of random scrutiny that incentivises those preparing the legislation to get it right in all cases, because they don't know where the spotlight's going to fall.
Not heard that concept before. That's a very interesting one. Do you want to explain sift and scrutinise to?
Well, I won't bore you with this, but I mean, we submitted evidence to the Procedure Committee just before Parliament dissolved for the election, in which we identified 15 core problems with the way the Commons scrutinises statutory instruments. The critical one is that, and it's reflected in the government's white paper, I mean, they don't accurately reflect the nature of procedures. They imply in this that MPs can require a debate and require a vote. That's actually not true, fundamentally because the government controls the parliamentary timetable. And therefore, whether there is a vote within the ascribed scrutiny period is a matter for the government, not the MPs. You can be the leader of the opposition, and in the 2015-16 parliamentary session he demanded a debate and a vote on, I think it was 12 statutory instruments. The government accorded time only 5 times. So there's a fundamental problem with the ability of MPs to debate the statutory instruments they want. What we're proposing in very, very simple terms is that there should be a new, abolish the current system, and there should be a new delegated legislation scrutiny committee. The technical scrutiny should continue to be done by the Joint Committee on Statutory Instruments, the new Delegated Legislation Scrutiny Committee will do the equivalent in the Commons that the Lords Secondary Legislation Scrutiny Committee does, with some additional criteria. All instruments would go to it to be sifted. That committee, a fairly large committee, would assess each of those instruments and decide whether or not there were policy issues that members might want to consider in more detail. It would send those to a subcommittee, potentially 8 to 9 subcommittees on thematic policy areas. They would consider those in more detail and report, not dissimilar to the way the EU scrutiny committee system works in the House of Lords. And they would then report to the House as to whether or not they thought the instrument should go through, or whether there were concerns that should be debated and discussed. Now, that will require a commitment of time and resource in the Commons. But again, I go back to the issue, if it is serious about carrying out its democratic responsibilities and scrutinising this stuff through Brexit, it has to do something. And this is the best model that we think we can come up with. You would have members of those subcommittees also drawn from select committees, so you get a degree of policy knowledge and a cycle of learning through the process. You'd review it after a couple of years, of course, but we think this would also resolve the problem, not just for Brexit, but for delegated legislation in the longer term. Parliamentary scrutiny, a bit like dogs are not just for Christmas, parliamentary scrutiny is not just for Brexit. And we think that this should be something that is embedded in the Commons in the longer term. We can send you a draft of the paper.
And David Davis did have some words, didn't he, when he announced when he spoke in the Commons about the not called the Great Repeal Bill White Paper, the Legislating the Exit White Paper, that he would talk to Parliament about doing this in partnership. I'm not quite sure whether that's been as big a gap as it has with the devolved.
And there is an issue about resourcing it, but at the moment, the House has to set up a committee, a delegated legislation committee, to consider every affirmative instrument. We'd be getting rid of those. So there is a resource saving to be had, and we think that it can be done, as it is in the Lords, within the required time period. So you wouldn't actually need to amend the Statutory Instrument Act to achieve this.
Okay, we can take that conversation further offline, I think.
Vernon Bogdan, I want to ask Akash about devolution. Agriculture is clearly devolved power. The devolution legislation states which powers are reserved. Anything not reserved is devolved. Now, the devolution legislation was drawn up in the context of our continuing membership of the EU, for presumably all these powers go back directly to the devolved bodies. Now, if the government, for perfectly good reasons, wants a more coordinated policy of agricultural subsidy and protection, so you can't have 4 totally different policies, they have to claw back some of those powers, do they not, which means amending the devolution legislation. Now, although that could formally be done without the consent of the devolved bodies, it can't in practice. Is that right? So they'll need the consent of the devolved bodies to get a coordinated policy in agriculture and fisheries and any other body, any other powers that are devolved in the devolution legislation.
Okay. Akash, do you want to take that and then we'll line?
Yes, well, I mean, Vernon, I generally share that analysis, but I think actually what that speaks to is the fact that the governments, the respective governments, seem to be coming at this set of issues from a quite different constitutional understanding. So, I mean, certainly, the Scottish and Welsh governments have argued consistently and believe very strongly that exactly what you have outlined is the case. Powers over agriculture, fisheries, the environment, that are not listed as reserved powers, for example, under Schedule 5 of the Scotland Act, we're talking about Scotland, but are currently heavily subject to EU law, will post-Brexit by default become entirely devolved powers in practice as well as in theory. And therefore, if new frameworks are to be created to ensure coordination in these areas across the UK, they will have to be negotiated and agreed by consensus between the 4 nations coming together on a basis of equal partners in a sort of federal style model. However, I mean, the British government while it has conceded that consent will be required for the repeal bill, at least some parts of the repeal bill, and as we've said, there's all the other bills as well that we wait to see more detail on. Their approach is, of course, rather different. I mean, all that has been committed to by the British government in the Repeal Bill White Paper and also, I think, in the Conservative Manifesto is that no decisions currently taken at the devolved level will be taken away from them. And yes, there's an expectation that there'll be that the decision-making power of the devolved bodies will be increased. But they've not conceded that point that the default is this is all devolved. So I think when it comes to it, this is the problem. I mean, you have Westminster thinking about these powers as being currently at the level of the EU. We're taking back control. They're coming back to Westminster. Then there'll be some kind of decision-making process, yes, with consultation with the devolved bodies and others. But ultimately, with this, the ultimate say taken at Westminster about which elements of those powers are then cascaded down to Edinburgh, Cardiff, and Belfast. In Edinburgh and Cardiff, certainly, Belfast is a bit messier, of course. There's a consensus. It's not just a sort of nationalist viewpoint. It goes beyond that. Those powers are held at the devolved level, subject to EU regulation. And yes, there'll be a need for UK frameworks, but we have to negotiate and agree them. So there isn't an easy way to square that circle because they just fundamentally aren't approaching it on the basis of a shared understanding of the Constitution. So
legally, the powers are with the devolved body.
yes, if you want to change that, but you would have to make amendments to the devolution legislation. That would necessarily trigger Sewell. And then does Westminster say, well, Sewell only applies normally, this isn't normally, or does it simply say, well, this isn't judiciable anyway and Parliament is sovereign? I mean, they have those cards, don't they, to play if it comes to it, but that would be pretty messy. And I think, constitutional crisis wouldn't be an understatement if that's where we end up.
Okay, well, Stephen may have a solution to this. Stephen, you wanted to come in?
Yeah, I mean, there is a question about the extent to which returned powers flow down to the devolves, and there are, I think, probably some legal arguments that you can move both ways. But that question is subordinate to the much more important question, which is where the money comes to fund any functions that do flow down to the devolves. Because insofar as there are, for example, agricultural subsidies provided by Europe, they are not shared out between the different parts of the United Kingdom according to the Barnett formula. So you've got to sort that out before you sort out where the functions go.
So that might be a handy bit of leverage. Dianne, do Labour have, obviously Carwyn Jones is a very interested big player in this, Labour government in Cardiff. Do you have a view on where this comes out?
Well, in a way, it reflects what was said earlier, was that there's been quite a lack of trust by the fact that they've not been involved. And I think had that been different, then it would have been much easier to find a way forward on this. But it's now quite a lack of trust, and I think the government really needs to mend that fence before we know quite which way to go forward.
I'm going to try and take a clutch question. So we've got there and then just behind Joe. Yes.
Hi, I'm Darren Jones, the new Labour MP for Bristol North West, looking for one of the paddles that Ruth is offering to get us up the creek of the next Parliament. One of my questions is about the moving nature of EU law. And there's two issues I can see which I don't know the answer to, which is firstly, EU law which is published in the journal but is not yet implemented into UK law before Brexit. So an example of that might be the Digital Content Directive or the new Telecoms Framework Rules and the Communications Code. How should that be managed? And the second one for me is EU law that is published but has a phased implementation period. So an example might be the European Accessibility Act, which might come into law before Brexit but has a 6-year or a proposed 6-year phased implementation of how it applies to goods and services in the market. So how would we manage that under the Repeal Bill, and how would that work in a transitionary period as well?
Okay, Stephen, do you want to take that one? Well, then we'll go back there.
Quite a technical question. I think there are issues around commencement and how of EU law and what's in the pipeline, what isn't in the pipeline. I was preparing what I was going to say today last week, and then last night I looked at the internet to see to what extent I was agreeing or disagreeing with what other people had said. And I found a paper from Linklaters on the internet that has a whole section on commencement, and I think the best thing I can do is to refer you to it, because they come up with some recommendations. I don't agree with all the recommendations, but they certainly put the problem very clearly.
I think it's a really interesting issue as well, with ministers currently engaging with EU laws that are going through. There's some have been quite diligent, and others I think, aren't we out now? Do we have to do that? And yet under this, quite a lot of that body will just be transferred into UK law and will have implications for us. So don't drop the ball on things going through in the next 21 months. Yes, we had...
Paul from Green Alliance. So as well as the transposing of the regulations for environmental protections in EU law, sometimes the excess stuff around the protections are just as important. I'm thinking things like principles, so like the precautionary principle, the polluter pays principle. Is it possible to get those across in the Great Repeal Bill as well?
Okay. Stephen, would we put these principles on the face of the Great Repeal Bill? Would you expect that?
I mean, what the White Paper proposes is that the law at the moment of exit is to continue as it is at the moment, and then needs to be construed in accordance with that. I mean, I think there's an issue about that, because if you talk about the directly applicable law and there's the implemented law, and there is an extent to which implemented law may not be wholly compatible with directly applicable law. You know, you have directives that they may not have been properly implemented. That there's a question of whether, in relation to events that happen after exit day, you take our implementation as the law and then construe it only insofar as it's ambiguous to comply with directly applicable law, or whether you say, well, directly applicable law prevails, and if there's something in some set of 2.2 regulations that doesn't quite fit, then we must go back and change it, even for future events. But the principles will carry forward insofar as they're used for construing things that are to continue to have effect under the Great Repeal Bill. That's what has been said, that you construe it in that way. And all general principles of EU law are rules of construction of law in words. There is no common law of the European Union. That everything is a way of construing some instrument that's been created, either a treaty or a...
So our judges go on construing EU law or EU-derived law in the same way as the European Court would have done afterwards. They sort of, go on with sort of, interpretive approach or whatever. What were they trying to achieve? Things like that when they do it afterwards. Because we're taking all that case law into UK law as well, aren't we, as part of the Great Repeal Bill?
Up to the point of exit, yes. Yeah. After exit, no, but... Well, possibly no.
Which is what I was going to come on to. I think
you have to think about it in the context of where we are. Where we are is that we have a rule in Section 3 of the European Communities Act incorporating ECJ jurisprudence into the law. Afterwards, if you repeal Section 3, I think the only practical way to deal with ECJ jurisprudence, but maybe the repeal bill will prove me wrong, is to say Section 3 is not to have effect in relation to post-exit jurisprudence, and then to leave things uncertain, or at least unexpressed, in relation to the rest. And that, I think, then throws you back on normal principles of construction, which are that provisions of UK law have to be construed so far as they can be, as consistent with any international obligations which they implement, and that judgments of foreign courts, of which we would count the ECJ, are of persuasive but not binding authority.
Do you think there should be, we have, our colleague Raphael Hogarth wrote a piece last week, an IFG analysis piece on the ECJ and Brexit, and said that basically that the government shouldn't leave a vacuum. It should actually instruct on the face of the bill that the courts can take account of future EU judgments on things that are still EU-derived law, rather than leaving it up to judges to decide whether they should or not, because that would potentially expose the judiciary. And that's something I think the judges had asked for at a House of Lords committee.
Well, the most difficult law to express is the law that is already the law. If it is already the law that the courts will take into account foreign judgments as persuasive, and you can't argue that that was somehow removed by Section 3, which I don't think you should, then the easiest way to produce status quo is to say nothing.
All right, so you think Lady Justice Hallett's saying she'd like something a bit more explicit was...
They should accept the cases, they should make it clear in what cases Section 3 does not apply.
Okay. David?
Well, David House, the University of Cambridge, just to illustrate how that actually doesn't work, it's just so difficult. Imagine a case, let's take the general data protection regulation. So that's in force before Brexit. After Brexit, the CJEU declares all or part of that regulation invalid in EU law because it was contrary to the treaty. And of course, EU law has a hierarchy of norms, so the treaty is higher than the regulation. The question then is, how do we deal with that decision in UK law? Because you could argue that the repeal of Section 3 makes no difference because this regulation was never valid in EU law and wasn't valid at the point of Brexit. And therefore it's automatically no longer valid in UK law. Or you could say, oh, well, the repeal of Section 3 works, in which case it's up to our courts to decide whether to apply the treaty. Notice, apply the treaty, the EU treaty being applied in our courts. Apply the treaty in the same way as the CJEU did in that case. Or you can flatten the EU hierarchy and say our courts can't change anything and everything has to be done by Parliament. And you've also got a problem there that any temporary power you have in the bill might not work because this might happen years afterwards.
Okay, Stephen, very quick response there, and then if you could just give them...
I agree it's a problem. I would answer it in the second way you suggest, but I would also do what the white paper does not suggest, which is to say that in relation to events happening after exit day, you take the UK implementation right or wrong as the law, and that's not there at the moment, but I think it's the only way to achieve certainty and stability, which is what the Great Repeal is supposed to do.
Okay, we'll get a couple more questions in because we're running up against our deadline, yes.
Ruth Deach, House of Lords. The Lord Chief Justice made a speech last week addressing this question, and he said, if I understood it properly, that he would like to see a provision saying that our courts will take due regard. He seems to know what that means. Due regard of EU law at the moment of exit. The other thing he said, trying to be helpful, was, and I think this came from the Law Commission too, that the Law Commission stand ready to be used to help with technical, if not political, elements of the drafting, where you've got laws about conflicts of jurisdiction and so on. And we need all the help we can get. So I'm wondering if Sir Stephen knows whether the Law Commission could help there. And then a final, I hope, helpful point. Have we been here before? Is there anything to be learned from the handover of Hong Kong and going back earlier when Canada left the British Empire and when Australia left? They must have faced the same issues.
I think other people are suggesting we could look at the separation of Ireland as well as a precedent. Stephen, quickly.
Taking the last point first, yes, I mean, every Independence Act had a continuity of the law provision in it, and they are all there. They don't have the same problems that we have with the EU because you don't have this extra issue of ceasing to be a member of an organisation and interrelations with the other countries. So far as, I'm afraid for the reasons I've given, I disagree with the LCJ about due regard. I think if you're going to say something with respect to him as meaningless as that, you might as well not say anything at all. And so far as the Law Commission is concerned, I'm sure all lawyers in government are being enlisted to help as much as possible.
Bill.
Bill Wells. I thought I understood this until I came here.
Maybe a good point to end. Anyway, yes, final question.
I thought the Repeal Act was where we agreed to sign up to the acquis, including frictionless trade, for example, frictionless trade. And so therefore we're just and the other acts were where you don't agree to sign up to the acquis. And so I've never understood why there's this big debate about the single market or anything. But why I think it's important is that not only do we have to convince the UK, we have to convince the European Union that we've signed up to the acquis in the Great Repeal Act. And in that context, I think all the position papers from the Commission are very dangerous, in the sense that they set out what the acquis is that doesn't hold in any single country because of subsidiarity or whatever. And as we've seen on the citizenship stuff, I think, it was a fair and generous offer because it's what's being implemented in line with the acquis at the moment.
Well, I don't think it is on EU systems actually, but anyway.
Can I say that's not what the Repeal Bill is? The Repeal Bill is simply putting into domestic law the things over which we have control and can have control. So they're the regulations that are already law, which have become our law by backdoor. So these are regulations that we implement, that we actually act on now. All the stuff that needs reciprocity, all the stuff that needs the agreement of a counterparty, the European Union, none of that, I think I'm right, none of that will be in the Repeal Bill. That will either be in the withdrawal agreement, which is the one that will come to both houses sometime before the day we leave, or even after that in the deal that we have, either to have a free trade agreement or whatever. And that will only come to us, I guess, help lawyers, in the form of a treaty that would come to us under CRAG in due course, and that is some time off. So the Repeal Bill is a very short, in a sense, small targeted bit that is only the things over which Parliament can absolutely decide. So nothing where we need a counterparty to agree it.
I think that's absolutely right, but I think what the repeal does is to incorporate into UK law the things that are as you say, within the power for us to implement with UK law without anybody else cooperating. But the extent to which you've got reciprocal obligations does create the question whether or not we've carried over our side of the reciprocal obligation if they haven't carried over theirs. And that's a distinction that somehow is going to have to appear in the Great Repeal Bill, and how it is defined is by no means clear.
Okay, this is an argument that keeps going on. Whatever, yes.
Thank you. Chris Francis, SAP. We've mentioned the treaties, regulations and directives. We have issues like blocks of directives, like the new approach directives that define the single market by and large, and you've mentioned just now the reciprocal issue. Many of these have explicit obligations that exist on an implicit understanding that they apply to all member states, like the GDPR, like the rights of establishment under the Services Directive. So having heard the debate, can we actually have something that is as simple as has been suggested when we have these different hierarchies and different categories, or will we by need go into how these categories will be treated and be treaties, regulations and directives and mutual issues differently? Particularly with mutual issues, as every single one of these seems to have enormous policy implications.
Yeah. Stephen, Dianne, here.
I think all the mutual stuff will have to be by negotiations, whether it's mutual recognition of court judgments or professional qualifications, or, on a consumer, whether you can still take your car and it be without going back to a green card when you have to take your car aboard, or health insurance, or any of those. Anything that needs reciprocity, it seems to me, cannot be dealt with under the Repeal Bill. But there's someone who's much more knowledgeable on my right, I'm glad to say.
Stephen?
Yes, I mean, this is why I was talking about the two elements. Taking EU law away as a source of law and membership. Because if you keep everything carried over that disappears because EU law has ceased to be a source, you're still left with this question: what do we want to continue with when we're a member, and what do we not? And you can do that in one of two ways. You can either say, well, we'll carry everything over and then we'll use the power to make it work, to take out the things that don't work, which may be what the white paper is suggesting, but I don't think it can be. Or we will find some we will find some general tests that will take most of the reciprocal stuff out, or maybe all of it, maybe a bit too much, and we'll use the power to put back the bits we want, or to leave out the bits that we've found we haven't left out when we thought we should have done. But I wholly agree that that issue is an issue that needs to be addressed, because you cannot say the acquis is carried over as if we were still a member and think you've done the job, because you haven't.
I mean, it might be a precondition for saying, look, we've still got the acquis, it's still there, and now let's talk about the agreement we have that says we'll go on observing it, stuff like that. But actually, one of the things that's really interesting, I think, is that the EU has this network of multiple agreements with, third countries, and one of the effects of us leaving is we become a third country. So, Switzerland has 120 bilateral treaties, some of these comprehensive agreements like the one we've seen most recently with Canada, but it's quite interesting that that's probably the sort of agreement we end up with to give effect to sharing, mutual recognition, all these other things we're talking about, at least under the government's proposal, rather than some off-the-shelf
And some
thing.
really urgent ones, like information sharing is going to be really urgent, and it will underpin an awful lot of these other issues. Can I say one other word? I didn't talk about it earlier when someone talked about SIs. Of course, we can stop statutory instruments in the House of Lords. I'm not threatening that we will.
Okay, well,
but don't forget that we do have that power.
Well, we're now over time for our sort of hours-long tour through the Repeal Bill, which hopefully will be coming out sometime soon. You can benchmark all of that. There's no absolutely burning question. Could I just ask you all to thank our fantastic panel for all their answers?